Hello and welcome to Courts Today by Live Law. Let's get to today's top legal updates. Plea in Supreme Court claims Indian government threw 43 Rohingyas into the sea during deportation. Plea in Supreme Court over demolition of Waqf Dargah in Uttarakhand despite centre's assurance in court. Supreme Court scraps point-based system for senior advocates, asks High Courts to revise rules. Centre informs Supreme Court it has withdrawn blocking of 4 p.m. News YouTube channel. Supreme Court says linking Mundra Port heroin seizure to terror financing is premature at this stage. CJI Sanjiv Khanna bids farewell. Says public trust in judiciary must be earned, not demanded. I'm your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel because your support means the world to us. A petition is filed in the Supreme Court by 2 Rohingya refugees. The petition alleges that 43 Rohingya, including women, children, the elderly and even cancer patients, were forcibly deported by Indian authorities, first arrested under the pretext of collecting biometric data, then secretly flown to Port Blair and eventually abandoned in international waters near Myanmar. The group was reportedly misled into believing they'd be taken to Indonesia, only to find themselves back in the very country they fled, Myanmar. Families were torn apart, children separated from mothers, and many forced to swim to shore. The petition, which lists names and UNHRC card numbers of the deportees, calls the move illegal, inhuman, and unconstitutional. It demands that the government of India bring the refugees back and pay rupees 50 lakh in compensation to each one. Although India is not a signatory to the 1951 UN Refugee Convention, the plea invokes the principle of non-refoulement already recognized by Indian courts, which bars sending refugees back into danger. The case will next be heard on July 31st. The Supreme Court has issued notice to top Uttarakhand officials in a contempt case over the alleged illegal demolition of a registered Waqf property, Dargah Hazrat Kamal Shah in Dehradun. The petition claims that the demolition done using bulldozers on the night of April 25-26, 2025 violated the Union government's assurance to the Supreme Court that no Waqf property's status or character would be changed until the next hearing in the Waqf Amendment Act case. This assurance was given by Solicitor General Tushar Mehta on April 17th. Senior advocate Kapil Sibal, representing the petitioner, argued that the Dargah had been registered as a Waqf since 1982 and was officially notified and mapped in the Waqf Asset Management System of India. The demolition was allegedly carried out without notice, based on a complaint filed on the Chief Minister's portal. The petitioners cited a Supreme Court ruling from November 2024 that prohibits demolitions without proper notice. The court has now tagged this case with a larger batch of petitions challenging the Waqf Amendment Act 2025 and will hear it together in due course. In a major change to the senior advocate designation process, the Supreme Court has scrapped the point-based marking system introduced in the Indira Jaising judgments of 2017 and 2023. A bench of Justices Abhay S. Oak, Ujjal Bhuyan and S.V.N. Bhatti ruled that this system, which awarded points based on years of practice, reported judgments, publications and interviews, will no longer be used by the Supreme Court or High Courts. Instead, all High Courts must frame new rules within 4 months, ensuring transparency and fairness while keeping the full court in charge of the final decision. The court stressed that senior designations must be decided through consensus or democratic voting, and interviews should not be a mandatory part of the process. It also ruled that advocates can continue to apply for the designation, and courts may designate advocates even without an application in deserving cases. The bench noted the need for more inclusive representation, especially for trial court lawyers. The court appreciated Indira Jaisingh's efforts to reform the system and confirmed that ongoing applications under the old system can continue, but all new processes must follow the new guidelines. The Supreme Court was informed that the central government has withdrawn the blocking order against the 4 p.m. News YouTube channel. Senior advocate Kapil Sibal, appearing for the channel's editor Sanjay Sharma, confirmed that the channel is now unblocked. However, the petition challenging the legality of the IT Blocking Rules 2009 remains active and may be tagged with a similar pending case. Justice B.R. Gavai remarked that the matter now survives only for academic purposes. Sharma's petition had called the blocking arbitrary and unconstitutional, claiming it was done without prior notice or a hearing, violating his fundamental right to free speech under Article 19(1)(a). He sought production of the government's blocking order and demanded that it be quashed. He also urged the court to read down certain provisions of the 2009 rules to ensure that content creators are given prior notice, hearing, and copies of blocking orders. The court had earlier issued notice to the Centre, the Ministry of Home Affairs, and even YouTube. Though interim relief is now irrelevant due to the unblocking, the larger issue of procedural fairness under the blocking rules remains under consideration. The Supreme Court on Tuesday refused to grant bail to Harpreet Singh Talwar, alias Kabir Talwar, an accused in the 2021 Mundra Port case involving the seizure of nearly 3,000 kilograms of heroin. However, the court rejected the National Investigation Agency's allegation that the drug proceeds were used to fund terrorism, calling it premature and speculative. A bench of Justices Suryakant and N.K. Singh said that at this stage there is no compelling reason to link the accused to any banned terrorist group like Lashkar-e-Taiba, as claimed by the NIA. The court emphasized that such serious charges require strong and clear evidence, which must be presented at trial. Despite rejecting bail, the court allowed the accused to reapply after 6 months or after significant progress in the trial. The NIA had alleged that heroin from Afghanistan was smuggled into India disguised as legal goods and that Talwar was involved in distributing it under the instructions of co-accused Faridoon Amani to raise funds for Lashkar-e-Taiba. Earlier, the court also noted concern over the accused's children facing bullying due to those serious allegations. Today, Chief Justice of India Sanjiv Khanna received a warm and heartfelt farewell at the Supreme Court on his last day in office. In a packed courtroom, senior legal figures including Attorney General R. Venkatramani and Solicitor General Tushar Mehta praised CJI Khanna for his clarity in judgments and dedication to upholding liberty and the Constitution. Kapil Sibal said CJI Khanna carried forward the legacy of his uncle, Justice H.R. Khanna, and always encouraged young lawyers. Additional Solicitor General S.V. Raju highlighted his simplicity and referenced a live law article that described how CJI Khanna defended the Constitution without seeking the limelight. Several other senior advocates praised him for his fairness, patience, and deep commitment to justice. Justice Gavai, the next CJI, described him as a gentleman to the core and credited him for his push for transparency, including publishing judges' asset declarations. CJI Khanna, in his farewell speech, said the judiciary earns public trust through both judges and lawyers and called the bar its conscience keeper. He said the public trust which the judiciary has, it cannot be commanded, it has to be earned. He expressed full confidence in Justice Gavai and thanked everyone for their kind words and support throughout his tenure.